Okay, so there's going to be times where the original owner of the overage, the claimant, is going to be deceased. And the first thing you want to find out if the claimant is deceased is if they have any heirs or children or family. Because depending on the situation in which the person died, whether they had a will or a trust in place, that will determine who will get the overage in succession from the original owner. So those are called heirs. So if you have, for example, a mother and father, and both are deceased and they had one child, then that child would be the heir of any assets of that mother and father. Now, that could be directed either through a will or a trust. In some cases, if there is no will or trust, then it has to go through what's called probate. And probate is a legal process in which the court determines who gets the inherited assets. And usually you want to avoid probate unless it involves a substantial amount of money. But we try not to work too many probate cases just because they can get real messy and they require, attorneys, and it takes at least 6 months to even get the process started. So probate is one thing you want to avoid if you can, but if you have to, and it involves a substantial amount of money, then yeah, you could get an attorney and work with probate. Now, usually if you go to the states or counties websites, there's something called the table of heirship. It just says, what the succession order is for heirs. So it would be mother and father, and then it'd be children. And then if no children, it would be the brother and sister or parents, just depending on what the table of heirship shows. So let me show you an example of what that looks like so you can get an idea of what order these assets will be handed down, including overages, to the heirs. So let's take a look. Okay, so here's a real simple succession chart. And succession just means order. That's really what it means, and who succeeds the previous person. That's all it really means. So this is an example with no will or trust. And this is real straightforward. If you have mom and dad, and mom or dad passes away, the spouse will automatically get the assets of either mom or dad. In this case, the children wouldn't get anything unless there was a will or a trust in place. So one of the first things I ask my client when I'm speaking to them, especially if it's involving a deceased claimant or a deceased owner of the overage, is was there a will, or is there a will or trust in place? That's one of the first things I will ask, because that will determine what direction those assets will flow. So including overages. So that's the first thing I'm going to be asking is there a will or trust in place? And in this example, let's say dad died and there's 3 children. Well, the mother will automatically get the assets of dad with no will or trust in place. Now, if there was a will or trust directing a percentage to go to the children, then that would be enforced. So this is just a real simple, basic chart showing that example of no will and trust. Mom and dad passes away, even with children, it'll go to mom, all the assets. So the overage in this case, as long as they're still married, one thing you need to also know is, are they still married? Because if they're divorced and let's say, dad passed away, then there's going to be a little bit more work involved, because we need to know if there is a will and trust in place, because once the marriage is severed, then they're no longer a legally binding or looked at as a single unit by the state. So keep that in mind. 2 most important questions: is there a will or trust in place? And are mom and dad divorced or still together? So keep that in mind. Second chart here is let's say you have mom and dad and, spouse. Let's say dad's left and then mom passes away, and now there's just one parent, but then dad passes away and now there's no will or trust in place in this example. Then the assets will be divided by the amount of children depending on the dollar amount. And I'm going to show you a chart of different states where if there's a certain dollar amount threshold of the overage, you can avoid probate. And a lot of people, especially in the overages and surplus funds world, don't know that dollar amount. So they think just because there's a no will or trust that, it's going to have to go through probate. But that's not necessarily true. It depends on the dollar threshold. And I'll show you a couple examples of that right now. So here in California, if the overage is no more than $166,000, $166,250, so $166,250, you could fill out what's called a affidavit for collection of personal property, and you can avoid probate. Now, this is with no will or trust in place. So because any overage falling under that $166,000 will allow you to, or allow the children to fill out a simple affidavit and avoid going through probate. So keep that in mind when you're working the state. Find out if there is a dollar threshold in which you can avoid probate for the kids or family when recovering the overage. And I'll show you an example of some other states and their dollar thresholds. Let's take a look. So now this is what I compiled over some time in different states and the dollar threshold. You could see California, 166,000, Nevada's 25,000, Texas, 75,000, Florida, 75,000. So as long as the overage does not exceed this dollar threshold, your claimant, like for example, the children, can fill out a simple affidavit and it'll avoid having to go through probate. Okay. So when you're working a state, you always want to find out what is the dollar threshold maximum in order to avoid probate? Because let's say I'm in, Texas and the overage is, $300,000 and there's no will or trust in place, then it will be directed through the probate courts. And then the courts will decide. That takes a long time.